days are short, the weeks are short, the months are short, the year has been long. But it's been a good year for us, and hopefully it's been a good year, for many of you as well, despite the obvious challenges in the world. Really thrilled to be here today to talk about a topic that is near and dear to our hearts, and I'm sure to many of yours as well, which is billing guidelines. And what we'd like to do, this is going to be a fireside sort of chat, if you will, and frankly, a fire sounds really good right now because I'm cold. I don't know about you, but I'm in New York and it's starting to get pretty chilly. But a fireside conversation between Sinead and me, and hopefully all of you through the questions as well, about some of the common misconceptions, I think, about billing guidelines, some of the assumptions that are made that in the real world don't necessarily hold true, and some ideas that we have from working with corporate legal teams over the course of more than half a decade now to improve the quality and the effectiveness of billing guidelines, and generally to deliver transparency and shared expectations to everybody participating in the delivery of legal services. So my name is Kevin Cohn. I'm the Chief Customer Officer of BrightFlag. For those of you who aren't familiar with BrightFlag, we're a provider of legal spend management and legal matter management software to corporate legal teams. Founded in Dublin, we've been around for about a half a decade now, growing very quickly, and we serve a wide variety of corporate legal team customers, and of course engage with their law firm partners in the process of doing so. So I'm thrilled to introduce my sort of guest on today's session, Sinead Kenny, who is one of BrightFlag's senior customer success managers and a subject matter expert. Sinead, thanks for joining me today.
Thank you, Kevin. I'm delighted to be here and, as you say, talk about a topic that's very important to us and our clients. Really excited for the engagement that we get here.
Yeah, Sinead, I would love if we could just start, because you have such an interesting background, and you, me, and Colin were actually discussing this right before we went live. Share, if you could, how you came to arrive at BrightFlag and what has informed your worldview on the delivery of legal services and legal operations.
Sure. It's a bit of a long journey. I studied law and accountancy, so the same degree as Colin, in the University of Limerick. From there, I went into Matheson, which is one of the largest Irish corporate firms. I trained and worked there mainly in commercial restructuring and insolvency. It was back in maybe between 2010 and 2014, so there was a lot of loan sales in Ireland. So I was working on a lot of large projects within the law firm where we were cutting across a lot of different departments. So I got good exposure on commercial litigation, e-discovery projects, and loan sale agreements. I spent maybe 3 or 4 years working as a qualified lawyer there, and kind of wanted a change. I wanted to get into something that was more business orientated, but didn't really know what. And one of the co-founders, Alex Kelly, had actually trained and worked in the same firm. So I met him for a coffee. It was very impromptu, but I ended up meeting the two founders of BrightFlag. And as they spoke to me and told me about their vision for BrightFlag and what they wanted to do, it just clicked with me that this was exactly what I should get into. Having worked in a law firm, enjoyed it and really enjoyed the training. The idea of helping people, work more effectively, manage their time better, get more value out of, the important work that they're doing really resonated with me. So I was one of the first members of BrightFlag. So I've been there for nearly 5 years now. We've grown a lot and we've learned a lot from our clients. And what I do as a customer success manager now is work with the clients from implementation through to actually using the software. And my key driver and what I love about my job is helping them to get as much value as possible from the software. And what I mean by that is advising them on how best to set it up, and importantly, how best to set up billing guidelines, how to use the data to ensure that they're making strategic decisions that make sense, they're preserving the good relationships with their law firm, and they're getting value from BrightFlag. And the effective implementation and ongoing development of billing guidelines is one of my main focus areas with clients. So that's it in a nutshell, how I've got here and what I really like doing.
Great. Thanks, Sinead. And you mentioned the word value. I think that's a word we're going to come back to quite a bit as we go through today's session. So just to repeat, before we dive in, something that Colin said, please do add your questions in as they come up, and we'll sort of work them into the conversation. So Sinead, to kick us off, we have, I know, looks like a growing number of people who have joined us today with potentially differing levels of prior experience and familiarity with billing guidelines. So starting at a high level before we work our way down, and we'll get to the details quickly, I think, but at a high level, what are billing guidelines?
In a nutshell, they're essentially a communication from a legal team to their external counsel as to what they want to be charged for and what they would not want to be charged for. So essentially, they create the parameters within which the law firm should behave. When I'm talking to clients about billing guidelines, I describe it as an opportunity to set the tone for value. So it's a really good opportunity to communicate to your law firms what it is that value means to you and what you expect from them in terms of how they staff matters and how they ultimately bill you. So it's that framework of value.
So you're using a few words there that, like, right away I want to double click and better understand if we're using the right terminology, because you used words like suggestions and indications of what should be done. And even the topic and the title, billing guidelines, is that the right term to be using? Is guideline the right word, or should it be something else?
Well, really, when I think about like the set of billing guidelines at an overall level, it's this framework within which you want the law firms to operate. But then I always think of it in two components. So I think they're like billing rules and billing guidelines. The guidelines are more subjective, the rules are not. That's really how I think about it. And when a legal team is creating or curating that set of billing guidelines, they should mindfully think about that distinction in developing the guidelines.
Got it. So give us, all right, so rules, billing rules, and then billing guidelines, all under this umbrella, which we're just going to call for now billing guidelines. So can you give us a few examples of rules and a few examples of guidelines so that we just have an illustration of the difference?
Sure, that makes sense. Well, to help you understand the difference between the two, I think of rules, so the billing rules, as just the basic requirements that any legal team would expect their law firm not to charge for. So irrespective of the type of matter, how strategically important it is, when the firm is working on it, they shouldn't charge for certain things like an overcharge on a rate. So where they've agreed rates, the rates should be as agreed. If they've agreed to give discounts, the discounts again should be honored. They should give sufficient information, so sufficient narrative detail. And another classic example of rules, actually, and one that clients really don't like to see on invoices, is where the law firm is charged for like prohibited expenses. What I mean by that is, where the law firm is charging for things such as photocopying, maybe unnecessary couriers, those types of expenses that really are seen as a sunk cost. And to further help people understand, I guess, when where a billing rule appears on an invoice, anybody could really reject that invoice for that charge. It doesn't require a subjective knowledge of the matter itself. You could, like with some of our bright flag clients, they'll actually automatically reject billing rules when they appear on an invoice. The guidelines, on the other hand, are much more subjective. So they require, in my opinion, what I see is they require a specific knowledge of the matter. An example of a billing guideline would be research. It's one of the best examples to give, because research, is something that law firms, it's one of the most important things that they'll deliver to the legal team. But sometimes there can be unnecessary research charged. So what the lawyer, the approver of an invoice will want to do when they see research being flagged or appearing on an invoice, they'll want to look at that and decide, well, was this warranted in the circumstances? Or maybe was it research to file an affidavit, something that they should know and shouldn't really be charging for. There's that discretionary element with the guidelines, which is not there with the billing rules.
Got it. Thanks, Sinead. And I see there's a question already, which Colin has responded to, but I'm just going to read it out and add to Colin's response as well, because I think it'll really set the tone for a lot of the rest of the webinar. Sandra, thank you for your question. The question is is this webinar meant for corporate legal teams or for law firm billing teams or for both? The answer is both. And as Colin said, and as we go through the topics that I've selected and that Sinead has graciously agreed to discuss with me, one of the themes that we're really going to keep coming back to is transparency and shared expectations. And Bright Flag sells its software to corporate legal teams, but it is used just as much by law firm billing teams. And what we're aiming to do when we talk about helping our customers to move from paying for time to paying for value, value is a two-way street, right? The law firm needs to be getting the right kind of value in the form of the right level of business, the right level of instruction for the appropriate, fees and rates. And in our view, and this is what we're going to discuss, billing guidelines are the sort of shared set of expectations for how that billing relationship is actually going to unfold over the period typically of many years and many matters. So appreciate the question, and I think that that's a really helpful clarification. So Sinead, you've given a few examples of billing guidelines, a few examples of billing rules, and I imagine that one of the ways that billing guidelines can go wrong, both for corporate legal teams and for law firms for that matter, is if the lines get blurred, right? If a reviewer of an invoice or if a law firm preparing an invoice ignores a rule, or alternatively, if a reviewer is maybe too strict with a guideline. Is that fair to say?
Definitely, yeah. Like one of the most important ingredients for effective guidelines, and one of the ways, again, to preserve that relationship between the legal team and the law firm is to ensure that there's consistency from the legal team in how they're managing their billing guidelines. It should be understood that, the breaches of the rules, such as rates, prohibited expenses, that's a no-no. You'll ask the law firm to correct that. With the guidelines, there's more scope for the lawyer to decide what to do, but it also helps, for the GC to set a mandate, to give some guiding principles around how we should approach the billing guidelines. So consistency and transparency is very important, and having the legal team understand internally, A, what their billing guidelines are, that's really important, and then B, how they treat the rules and how they treat the billing guidelines. And one other thing to say about guidelines is they can evolve, over time. And one thing we're seeing with our clients a lot this year is this idea of budgeting, right? So budgeting is something that all legal teams will want to have in their toolbox. They'll want the team to be setting budgets. But I would say that there's a sharpened kind of approach to budgeting now. And what I'm seeing our clients do is go to the law firms and say, look, budgeting, we have to be tighter on it this year. We need to make sure that we're proactively, as a legal team, managing the budget. And from the law firm perspective, that you understand that you need to proactively manage it as well. So it's actually a good example of that two-way communication flow that needs to happen on the expectations around the guidelines, and budgeting being a good example of that.
Yeah, and you mentioned the top-down sponsorship of billing guidelines being important, like, the GC setting a mandate. Let's talk about the other side of the equation. When the law firms are preparing the invoices, how can corporate legal teams engage with, the partners at their law firms to make sure that there's that top-down, buy-in on both sides?
Well, communication, Kevin, it has to, so let's say with billing guidelines, it's not enough for a legal team simply to attach it to the back of an engagement letter and send it out in an email. They have to be clear on why these things are important. The law firm needs to understand why budgeting is important this year for our legal team. Maybe explain to them, this is the parameters within which the legal team is working within the overall organization. We have to come in on budget, and we have to report to the CFO on that. I think the legal team making it really clear to the law firm the pressures that they're under will help the law firm understand. And the law firm legal team relationship is not like a typical supplier relationship. It's a very important and very strategic relationship, and one that needs to be preserved, and it needs to be very healthy. So communicating to the law firm the importance of these guidelines, why they matter and why they're there, is really important to make sure that the law firms understand, as you say.
Yeah, and I think that's a really great transition into the next topic that I wanted to discuss. Now that we've got sort of baseline understanding of what billing guidelines are, is there's another tightrope to walk. We talked about this tightrope between billing rules and billing guidelines, but there's another one which is this tightrope that corporate legal teams are walking, especially in 2020, especially in 2020, between driving cost control and spend diligence through billing guidelines versus maintaining those very important relationships as you were just discussing. So, so how do you do that? Because cost control and cost reduction is so important, especially when budgets are being cut, when demand is going up. But how do you balance that against maintaining the relationship?
Well, you need to balance it. It's one that has to be balanced, and it can be a challenging one to balance. We help our clients to do it. And what I see is there's three again core ingredients to strike the balance. The first, as we've talked about, is to separate the rules from the guidelines and make sure the internal team is clear and the law firm understands how we need to act. The second important ingredient is you can't just dump the guidelines on the law firms. You need to roll them out thoughtfully, mindfully. You need to explain why you're doing this, what your expectation is. And then the third thing is, so you've kind of made the internal team clear on rules and guidelines, you've communicated effectively to your law firms, and you've listened to their feedback. And then the third thing is transparency. So, you need to roll out the guidelines and then evaluate and see what's working and what isn't. If you do those three things, you're well on the road to striking the balance between managing the costs and preserving a good relationship.
Got it. So we already talked about the first piece. Let's go deep on the second piece, which is the rollout. Walk us through how you help organizations to conceptualize that rollout, if you could.
Sure. So the first thing is to, so you've come up with your billing guidelines, you've implemented them. I would say the first thing is to gather the information. So let's say from a Bright Flag perspective, you've built in the guidelines to your software, and this Bright Flag system will start to flag certain things. You should gather and analyze that information at an overall level. You put them out there, but don't act, essentially. The second thing you do, once you've evaluated what's happening across your law firms, you then start to act. So you look to enforce, okay? And that comes back to the rules, the guidelines, and the legal team being clear. And then the third thing that you do in terms of the rollout being effective is you assess what's working for us and what isn't, in terms of certain guidelines, certain rules. Once you've the information, once you've your data on your system, you can start to assess how is it actually working.
So, I mean, that first suggestion, Sinead, that you would roll out the billing guidelines, but then not immediately act on them, it seems a little counterintuitive because, from my experience at least, a lot of organizations that are looking to, implement legal spend management software or are looking to roll out or modify their billing guidelines, they're doing it because they want to enforce those guidelines. They want to achieve cost reduction. They want to improve their value for money. And yet what you're recommending is that they not do that immediately. So it's a little counterintuitive. Help me to better understand that.
Well, I think, you have to think long term when you're rolling out these billing guidelines. Again, as I said at the start, they're one of the most important tools that a legal team will use to derive value from their firms and make sure, that they're getting the value from the firms. The short-term gains that you would get from rolling them out and quickly enforcing, I don't think it would actually lead to a successful implementation. It's really important to gather the information and assess what's happening. Like, we actually had a customer meetup earlier, and a client who's been using the system for a year, she said exactly that. She said for the first 3 months, it was actually just a learning experience for them because it was the first time they got to see what was happening on their invoices at a granular level. And it would have been premature for them to act right away. Instead, they evaluated it, they talked within the legal team, they talked to the law firms, and then developed their strategy as to how they're going to enforce. Acting too quickly, I don't think it gets you the wins, and it might actually, it might not be so beneficial for the relationship with the firm.
Yeah, interesting. And I think, I know the example that you're talking about because we were on the same meetup this morning, and that happened to be a legal team that was implementing, legal spend management software and billing guidelines for the first time. But actually, you could have told the same story about a team that already had billing guidelines in place, but was looking to revisit them and maybe relaunch them because they weren't, effective, right? So how might the situation be different in your opinion if they were looking to do a relaunch versus a first time rollout?
Well, I guess like something that would factor into that is what didn't work the first time for them to have to relaunch it. I think that like if you're having to relaunch billing guidelines, it usually is the case that they're dormant to start with. So I think you would go back to that information gathering phase again, Kevin, and any of the clients that I've worked with where they have had to have a relaunch, let's say they bought Bright Flag and relaunched their flags, or their billing guidelines, it was because there was no action on them before. They weren't maybe getting the information that they now get from Bright Flag, or possibly they just didn't think about them mindfully. I think information gathering, when you're doing a relaunch or a new set of billing guidelines, is just really important.
Got it. Thanks, Sinead. I just want to highlight that I see that we have a question here around current industry best practice rules or guidelines that are the greatest challenge or frustration to law firms, and we are actually gonna come to that a bit later on, I think. So thanks for the question, Patricia. Okay, so we talked about the rollout and the importance of doing it in this staged process. That makes sense to me. So then the final piece then was enforcement, and I think this is where you typically end up with some of that friction, right? And it can be good friction, meaning you're having the right kinds of conversations. Equally, it could be bad friction if you haven't done the first two phases correctly, right? So tell us about where the pushback starts to show up.
Well, sometimes what can happen actually, like in terms of pushback, what can happen is like if you're not prepared, if the legal team aren't on the same page about what is expected of them, sometimes the pushback can actually come from the in-house lawyer themselves, not really wanting to push back on flags. And that's where, billing guidelines, as I should say. When you get that, it's, as you say, the first two phases haven't been clearly iterated, and you really need help. Like, if we stand back and think about the friction that can occur, it's where you really need help from somebody like myself, somebody in the legal ops team, to hold your hand through the change as a legal team member, because it is a change to have to push back on invoices, and it can be sometimes a cultural change for a team to have to do that. So, you need to be prepared. There needs to be clear communication within the legal team as to what are the expectations. How do we talk to our law firms? So ideally, in an ideal world, senior management will go out to their law firms. Where I've seen it work really well, I had one large insurer who actually kind of built out billing guidelines as they were going live with us. They did that information gathering stage, and at the first set of quarterly meetings with their law firms, they actually brought the information into the meetings. They explained to them, look, this is what's happening. This is how our guidelines are looking across the board. Here's how you're performing, and they anonymized some of their law firm data. They were really clear about what was happening, and they were also really clear about what would happen next, i.e. the enforcement. So when you do it like that, you're much more likely to negate the friction that can occur. In my mind, there's kind of, when I work with a client, there's two areas that you work on. You work with the legal team, making sure that they feel prepared for this change, they're clear on what's expected, and you help the, GC or the legal ops, whoever in the team is strategically talking to the law firms, to make sure that they're clear as well on what's expected and how it's going to happen. When you do that, you negate the friction. Friction occurs where people aren't clear on the expectations. That's my opinion on billing guidelines and what I've seen play out.
So really, you're getting into transparency, which is the third piece of the puzzle that you mentioned. And just before we dig into transparency, I want to again highlight a few questions that have come in here that we're going to address, and I think we're coming to a naturally good point to address them. So we had that first question around some of the guidelines that are sort of best practices and might cause challenges. Again, we're going to come to that one shortly. There's another question, this one from Stephanie. Are you finding that different types of firms are more or less accepting of guidelines or spend management software generally? Any advice for how to overcome that reluctance? So I'd like to maybe summarize what we've discussed so far, Sinead, which is that one of the very common misconceptions in our opinion and experience, and I'm sorry to say that we have seen it with bright flag customers as well. It's not limited to non-bright flag customers. Is this this belief that billing guidelines can be used as a sort of way to beat up the law firms and to just indiscriminately reduce spend. And that's not how we think that billing guidelines should be used. That's not how we encourage customers to use billing guidelines. I also think that there's a misconception, and Sinead, I'd love to get your view on this in a minute as well. I also think there's a misconception that law firms are mostly for catching bad actors, right? And that many law firms are bad actors, and if you use billing guidelines and if you use spend management software, the main reason to use it is to catch the bad actors so you aren't overcharged. The reality could not be further from the truth, in my opinion. Even if law firms are doing the right thing, it doesn't necessarily mean that expectations are aligned and that the appropriate level of transparency is there. So Sinead, I'll turn the question over to you as well. How have you found that different law firms react to billing guidelines, react to spend management software? Is there a big separation between the people who react very positively and very negatively? Are there particular factors that you've seen, sort of patterns that you can detect?
I would say where it doesn't work so well and where friction can occur and kickback is where the law firms don't understand why the legal team are rolling it out. Again, it's communication. If you don't explain why you're doing it, and also explain that, to your point, the purpose of it is to not only catch maybe some bad billing behavior, but also to just hone in and identify the really good law firms that are delivering value and making sure that you kind of reward them for that. If you don't explain the rationale behind why you're doing this initiative, it won't work so well. So communication with the law firm is absolutely essential. And like I said, mindful communication, open engagement. What one client did was actually circulate a draft set of guidelines and, had a special meeting specifically on how they talk, specifically on the billing guidelines to get the law firm's feedback and take on some of the things that they were saying. So for example, one law firm had said that, we zero rate a lot of time. We want that captured, or we want that to be captured by this legal spend management software. So they came back to us and we developed a flag that specifically captures where the law firm were zero rating and writing down things. So when they went to their next, review with the law firm, they could say, thank you. We can see through the data that you're actually going above and beyond in certain circumstances with your insights. So you need to pitch why you're doing it, why it's important for the legal team, why it's important for the overall organization, and also not just message it as like kind of a gotcha exercise. It's genuinely to evaluate the value and reward good behavior. I can't stress enough how important communication is, and it should come from the senior team members within the legal team and filter its way down across the individual lawyers as well. In terms of kickback, again, that relationship is sacred. I understand that. If you can explain the why, take them on the journey. Bright flag on board law firms, they train them, they offer a support desk. That really helps with the friction that can occur at the start. And just being clear, if law firms have problems, address them. Go to they'd come to me in Bright Flag and say, look, this is kind of causing some friction. What can we do to try and make it better? Like anything, often people just want to be listened to. So listening to law firms and taking their feedback is an important component of that. I hope that makes sense. It's a bit.
Yeah, it does. Yeah. So there are a few other questions that are coming in here. Let's I want to get back to that question about some of the common, billing guidelines that create confusion or cause trouble on both sides of the equation. Before we do that, let's just explore one other topic, which I think will serve as a really good baseline, which is leads, UTMS, billing guidelines. Often these different but related, terms or concepts are combined. They're discussed in the same breath. Walk us through, if you could, what is leads? What is UTBMS? How do they relate to billing guidelines?
Sure. So to start with, leads is a file format that's used to transfer legal spend data. So it's a really kind of efficient way for law firms to submit invoices through a system like Brightflag. So that's a leads. It's a file format. UTBMS codes, they're different to leads. There's some interaction in that. I think the leads committee oversee the UTBMS codes, but essentially what the UTBMS codes are, the objective of them is to try and provide some sort of code set or taxonomy to enable better understanding of the legal work. So you'll have activity codes like drafting, review, that type of thing that law firms will apply to their invoices. So leads is the file format. UTBMS is essentially a code set within that leads file format. In terms of how they're linked to billing guidelines, it is common to equate them and say that, enforcement of our guidelines will be based on UTBMS coding. But what I have seen in practice is there are a number of shortcomings with that approach. First off, the UTBMS will work on leads files. That's how it's coded. A lot of our clients would use PDF invoices, so you're not going to get the benefit of the UTBMS code set on a PDF. Another kind of shortcoming or a reason why I don't like to equate UTBMS with billing guidelines is you're relying on the law firm to code the work. And I can say from personal experience, because I did have to code myself as a lawyer sometimes, lawyers are really busy doing really important strategic stuff. Asking them to code their entries is not the most efficient use of their time. And if they're anything like me, a lot of my stuff was drafting. I just didn't have the time to kind of code it more granularly than that. But that might be more a reflection on me than them. And then the other things with UTBMS is that it doesn't actually cover all practice areas. So the large big ticket things like litigation, M&A, they have a UTBMS code set, but not every area of law does. So there's gaps there. And then the final thing, when we talk about billing guidelines, it's evolving all the time, right? So, Kevin, that there's certain rules that we have, like multiple participants on a call, that would never be picked up by UTBMS coding. So there's just some certain guidelines that just, can't equate back to your UTBMS coding.
Yeah. Okay, that's helpful, Sinead. So now let's move on to the question that we get, I would say most often about billing guidelines, which is the question that Patricia asked. And her question: can you share some of the current industry best practice billing guidelines that are the greatest challenge or frustration to law firms? And I'll modify the question a little bit. I want to talk about some of the most common and also some of the most controversial billing guidelines, because again, one of the themes here is, like, if you are a corporate legal team and you are viewing billing guidelines as something that you're going to put together, and to Sinead's point, you're going to attach to the end of an engagement letter and say, do or else, it's not going to go well. Law firms are going to push back against that, and with good reason. If, on the other hand, you are focusing on transparency, on collaboration, on true partnership, and billing guidelines are being used to establish that mutual understanding, those shared expectations, you are going to get a better result in terms of communication, in terms of strength of relationship, in terms of cost control. Nevertheless, there are some guidelines that are common. There are some guidelines that are controversial. Fair?
Yeah.
So, Sinead, let's start by talking about some of the ones that are common and typically not controversial.
Okay, well, the ones that are common, so the ones that aren't controversial to start with, they're the rules, right? So if things like prohibited expenses, rates, those types of things, clients, when they go live, they'll just start pushing back on them right away. They're not controversial because they're just basic no-nos that shouldn't be there. So that's kind of the low-hanging fruit, so to speak.
And sorry to interrupt you, but usually those are just mistakes, right? Like, we have to remember that humans are preparing these invoices. Mistakes are made. Nobody begrudges people for making a mistake. So most of the time, those catches are not, look at that bad actor, they're, oops, it was a typo, right?
Absolutely, yes. And we see from our own data that they do tend to dip over time. Like they're usually things that will stop appearing on invoices after, a couple of months, once there's been the enforcement, as we talked about, due to the, kind of the effective rollout of the guidelines. So they're the least controversial ones. Then you get into the billing guidelines, the discretionary form. They're more common, right? Because they're capturing things that law firms have to do anyway in order to actually do the work. And to stand back, like when you think about those types of guidelines, think about the activities lawyers typically do, right? And let's say you have a team of lawyers working on a matter. It's a group of people who are trying to get organized and deliver value into the client. So a good example, let's say, is internal communications, okay? The internal communications will appear across all of our clients. Lawyers need to talk to each other in order to make sure that they're delivering the best product for their client. So a certain amount of internal communications is totally acceptable, right? And is necessary in order for the client to get good value and good product from the law firm. However, it can be excessive at times. And it's back to that point on transparency. You need to be able to see what's going on. You need to be able to see, okay, well, what's the level of internal communications? Who are the people talking to each other? What are they talking about? And when you get to that level of granularity, then you can start to make tweaks, okay? And law firms typically will accept them where they see it's excessive. So I remember one client we had, they went live with us. They were doing like a bet the company litigation, and the internal communications were through the roof. It was so high that the GC got a bit of a fright. And what he did was, in a really like kind of straight up way, he messaged the relevant law firms working on the matter, said, look, this is the data that we're after getting. We didn't expect it to be this high. Can you explain, what's going on? Within 2 to 3 months, the internal communications did drop to a degree. Now, there's still some internal communications, but to me, that was a good example of a common guideline where it was excessive. The client talked about it with the law firms, and very quickly it was modified. And that, to me, was a good result in terms of internal communications. It's where you need the transparency. You need to be able to see what's going on to make that fair call as to whether or not you're getting value from your law firms. And again, I think a crucial point there was the conversation that they had with the law firms and explained, look, this is what we're seeing. We needed to change slightly, or explain to me why it's appearing. That's one common one that appears, internal communications. Linked to that is staffing of calls. So that's another one, Kevin, I'm sure you've heard clients talk about as well, right? Where there's lots of people on calls. That can be completely justified in circumstances, but typically if you've got high internal communications and you've also got a lot of lawyers dialing onto calls, that's going to start costing you a lot of money. And it may be that the law firm isn't, like I said, organizing itself in the most efficient way. Through looking at that data, through having a conversation with your law firm, you can preserve the good relationship, absolutely, but you can also knock some of that unnecessary time that's being billed. It's a balancing act, using your guidelines effectively. And it's one that requires that communication and that feedback to the law firm. When you're open with them, you give them that fair feedback, they will change. And, to the point that I can't remember the lady's name, but about firms pushing back, they typically won't, where there's a good relationship and where they understand what value means to the client. They will adjust and they'll modify how they're organizing or staffing the matter. So internal communications and staffing calls, they're two good examples from my perspective.
Yeah. So let's talk about a controversial one. one that causes, I would say, as much consternation within corporate legal teams as it does within law firms, which is block billing.
Yeah, I knew you were going to say that. Block billing, it's one that certainly evokes a lot of emotion from clients. Or there's lots of different opinions on block billing and the value of it. First of all, I would say that the approach towards block billing, like, it doesn't have to be black and white and like you just write down all block billing. That wouldn't necessarily be the right thing to do. What I've seen clients do to help manage this controversial billing guideline is to kind of build in that they'll allow block billing to a degree, but a certain element of it will be discounted. If you have block billing in your billing guidelines and you're seeing it appear across a lot of your invoices, as a CSM, if you are my client, I would say, look, I think you need to have a conversation about block billing. you can build in, like I say, an approach where you discount some proportion of it. But if it's appearing a lot, I do think it's something that you should have a conversation with your law firm on. Like when I think about when I block billed, it was typically, you know, at the end of a week, or maybe I forgot to put in some time or didn't get to record my time each day. And it actually wasn't good for me because I wasn't getting to articulate to the client all of the value add that I was doing. So my personal opinion, one of many on block billing, is I think that if it's excessive, it should be addressed and ask your firms to break out more. And I actually think by breaking it out more, the client, the legal team gets good value, but also the law firm get to really show all of the value add that they're providing to the client. And that's my opinion on it.
Yeah. So the reason that I love talking about about block billing, excuse me, as being this controversial billing guideline is because in my mind it wraps up so many of the different things that we've been talking about, you know, in this webinar today. Expectation setting, transparency, you know, focusing on what's really going to move the needle and not treating billing guidelines, you know, as a concept, as a contract that you cannot violate, but rather as an operating agreement between two parties. And so, like, I've never heard a corporate legal team say, if it was block billing, then I don't believe that the work was really done. I've never heard anything like that. I have, and I certainly don't support this position, but I have heard it's block billing, and therefore, you know, we don't think this is valuable, right? So the reality, I think, is somewhere in between, which is that corporate legal teams have a preference, all else being equal, not to see block billing because it reduces to some extent the granularity of data that they have about how their matters are being resourced. Whereas, and that can impact things like, you know, if you want to understand how much time was being spent drafting versus communicating, block billing can get in the way of that. Does it prevent it entirely? No, but you want your data to be as accurate as possible. On the flip side, I think most of our customers, and I think most corporate legal teams would agree that if you outright ban block billing, that you are putting an undue burden on your law firms, right? So you have to strike this balance. And I think, you know, Sinead, that's why you were saying effectively, if 5% of your invoice is block billing, you know, like you are largely conforming to the spirit of the billing guidelines. If 50% of the invoice is coming from block billing, and you and I have both seen invoices where 50% of an invoice came from a single block bill, that, you know, that's a problem, and it starts to materially impair the reviewer's ability to quickly and accurately assess, are the right people working on the right things and charging the right amount, you know, charging the right rates, you know, for that work. So that's why I actually love talking about block billing. If I had my way, you know, there would not be any block billing, but that would require having this phenomenal solution for, you know, lawyers to not have to enter all these narratives. But it really wraps up some of the things that I've heard from you today, repeating them again. Communication, transparency, reasonableness. I'm not sure that that's a word that we've used in the first 45 minutes, but I think it's a really important one. If legal teams are not reasonable, or if their law firms are not reasonable, there is going to be a problem. The relationship is going to break down. Yes. There is reasonableness. If both sides are assuming best intentions, then billing guidelines, drafted and tested correctly, rolled out correctly, made transparent through data, are going to strengthen that relationship rather than provide a bad kind of friction. Is that a fair summary?
Yes, absolutely. And it's a good point about reasonableness. It should be implied, but it's so important that you're reasonable with your law firms and that you work with them. Again, it's that partnership which is sacred. You have to work with them, and block billing is a good example of where sometimes it's necessary that they'll do it, but it's having that kind of cutoff or tolerance level, knowing your tolerance level and knowing when you actually have to have a conversation on it. Yeah. It's a really good summary, Kevin. And it encapsulates a lot of the different kind of, I guess, ingredients of billing guidelines and where they go right and where they go wrong.
I want to come back to a question that that Stephanie had asked about whether there are some types of firms that have maybe more challenges with billing guidelines than others. And I want to layer on top of that a question that James submitted. And James's question was, how do you manage disbursement vendors? For example, experts. Would you expect the law firm to cascade your billing guidelines down, to the subcontractors? And I'm wondering, Sinead, is that an area where sometimes you have more pushback because you're now, another layer removed from the legal team? How can legal teams and also law firms make that work?
Yeah. So to Stephanie's question about pushback, if you communicate the why, typically that won't happen. In practice, I think there was one client I had where actually a tier one, like Magic Circle firm, was very reluctant to give the detail narrative. And we were picking it up on the flags that just they weren't given detail. They were used to providing a fixed fee. And they were one of the most expensive firms on this client's portfolio of spend. So we had to have a conversation with them. They went back and, through kind of reiterating and doing a special meeting with them and kind of explaining it, they got them on board. So typically, I'm not just saying this, law firms they respect the relationship, they respect the legal team's need for this, so they will typically come on board. And so long as you communicate effectively, you explain the why, then Stephanie, the law firms will usually fall in line with that. And they can be really well rewarded because the data will start to pick up where they're like where they're billing really well and providing that value. The second point, which Kevin, sorry, it's gone out of my head briefly, but
it was the sort of sub vendors.
Yes. So some of my clients do roll out the billing guidelines. Usually it's a phase 2, right? So the phase 1 is the law firms, panel firms. They'll get them on board with the billing guidelines. You can have quite high expenses on your disbursements, particularly, let's say, from barrister fees, insurers. What will happen is a phase 2. So they'll actually start to get them to upload directly to the system, having rolled out the guidelines. So they'll do, the guidelines mightn't be as specific for them, and they might not be as detailed as what they would have for a law firm, but they will start to kind of build in certain things. One of the things that they start to ask for, because Bright Flag will analyze all the detail lines, they'll ask them to provide a little bit more detail in their description. That's the starting point of what I see with those third-party providers coming on board. And by doing that, then it's back to the phases we talked about before. You start to gather the information, you see how they're billing you, what work they're doing, and then you start to kind of curate guidelines specifically for them. So I have some clients that would actually have 2 sets of billing guidelines, one for their firms and then one for providers, which is it's more pared back, but it does give them it sets that framework in line for them. And then some clients don't want to do that. They just want the law firm to include it as a disbursement, and they don't really care about those expenses. So it comes down to the legal team's preference.
Got it. Sinead, I have one more question for you. This has all been really helpful. I want to end with a question about savings that legal teams typically come to expect from rolling out billing guidelines. And there's this expectation that if you roll billing guidelines out, you're going to get X% savings year after year after year. In reality, if things go well, you'll get X% savings in year 1, something considerably less than that in year 2, something even lower in year 3, and then maybe it'll sort of stay at that point in years 4 and on. Why is it that the percentage of savings drops from year 1 to year 2 typically?
Well, it's a good thing if it does. And the reason why it would is you've effectively rolled out your guidelines, right? So back to our initial conversation about the rules and the guidelines. When they're effectively rolled out, your rules will stop appearing, billing rules will stop appearing on your invoices. So that's going to negate, the savings in year 2, or the percentage of billing guideline breaches. And then over time, you just start to, your law firms will start to understand what's important for you. They'll start to kind of conform to so let's say, for example, research, they'll understand what you want to be charged for research, what you don't want to be charged for, and they'll typically modify their approach. So that's why, you will see a taper off if they're effectively rolled out. I'm concerned with clients where we don't see a tapering off, because it means we need to assess, okay, well, are these guidelines properly configured? So it's a good thing. It means the law firms are listening to you, they're understanding what value means, and they're starting to reflect that in the invoices that they submit for payment. And then, like, another thing to think about, so you've got billing guidelines, one of the most strategic, tools that a legal team can use to manage their spend. But, they're not the only thing that you want to look at. You want to also look at things like, okay, well, what's the resourcing like? You'll want to start looking at other things, and we kind of talk about it as a maturity journey for a client. But what they'll start to look at then is kind of resourcing levels, and maybe start working towards like alternative fee arrangements with their law firms, and start kind of getting value from there. So I think we lost you for a second, Kevin. So what I was saying was that billing guidelines are really important. If you effectively roll them out, you'll see a taper off over time, but value doesn't stop there. Like, billing guidelines are just one aspect of assessing value with firms. You then start to use the data to maybe look at resourcing, and some of my more mature clients are now at a point where they're happy with the guidelines. They're humming along nicely and they're working. They're now looking at, okay, well, how can we maybe work with our firms to strike up an alternative fee arrangement for certain work? So the law firm have more certainty, we have more certainty. The focus evolves over time as you become more mature as a legal team, and you're happy with your guidelines, so you move on to the next phase of, building on that relationship with your law firms and striking a good commercial arrangement.
That's great, Sinead. Notwithstanding the fact that I missed 30 seconds of what I'm sure was a great answer, I think what you were saying there was, and it's another one of these counterintuitive things about billing guidelines, is that if you do it well, they're going to start to fade into the background, right?
Yeah,
So
no,
they
definitely.
shouldn't be ever present. I mean, they will be, but they shouldn't be top of mind, because it will just become a part of the operating system, right?
Definitely, it should, and that's what we aim to. That's where we aim to get our clients, is that they're happy, they're confident in their guidelines, and they're confident the firms understand them and are living true to them, and then they can focus on other things, and work with that relationship with the law firms in other areas.
Yeah. Thanks, Sinead. Well, thank you everyone for joining today. We've reached the end of our fireside chat, and hopefully before my internet completely dies. If there are any final questions, we'd love to answer them in the last few minutes. And if not, hopefully you can, use the restroom, just meditate for 5 minutes. We do have a question here from Melanie. Question about more controversial guidelines. As a law firm, we regularly come up against guidelines that are simply unacceptable, not out of unwillingness, but because the risks are too great. For example, an unlimited liability or the confidentiality of data. We regularly notice that this is non-negotiable. What is your experience with this? How can we best deal with this? I think your mileage will vary, but my general advice, not as a lawyer generally, and certainly not as your lawyer, would be to shy away from accepting uncapped liability. That's pretty far afield of what we would consider to be a reasonable billing guideline. Confidentiality, of data is another. Like data protection, especially if you are covering personal data, is super important, and I think that there are reasonable expectations and reasonable standards that can be followed. But again, I think the jury is still out, even among the biggest, technology companies in the world, around what levels of liability, capped or uncapped, are reasonable there. I guess I would say, if you're a corporate legal team and you're thinking of putting anything related to liability or data protection into billing guidelines, you're probably approaching it the wrong way. There's probably a better forum to do that. And I would say the same to law firms. Sinead, I don't know if there's anything you would want to add.
definitely. They wouldn't come in. We wouldn't be thinking about those at all, or they wouldn't be front and center. There's other ways to deal with them.
Yeah. Okay. Well, if there are no other questions, thank you all again. Colin,
Marky's typing up a question.
Session.
Let's give him a couple of questions before it comes in. But I just want to thank you both. This was a phenomenal session. Very, very, very informative. Really appreciate your expertise and sharing it with the community. Attendees, I just want to thank you so much for, showing up and just participating. This is this is what it's about, just teasing out the topics and what creates value for you. Thank you very much. Looks like no questions coming in from Marty. We'll wait for the question, Marty. If there's a question, send it to me and I'll follow up with both Sinead and Kevin. With that, Bright Flag, thank you very much. Look forward to our next sessions in the new year, and happy holidays to everybody.
Colin.
Thank you, Colin. Stay safe, everyone. Take care.
Thank you. Bye.
Bye-bye.